I'm in the Money Matters Radio Network studios. My name is Jeffrey Davis, and I'm here with our litigation reporter, Mark Furman from Tarlow, Breed, Hart Rodgers. Mark, we have a very good, interesting story that you're going to talk to us about today.
Jeffrey, nice to be with you. We talk about how people can agree what law is going to apply, where their disputes will be settled, whether there will be arbitration or litigation. But can parties also agree that to have shorten the statute of limitations in the event a dispute arises? So under Massachusetts law, you have 6 years to bring a claim that somebody breached a contract. But can you agree that the statute of limitations is going to be 1 year, 2 years, 3 years, a much shorter amount of time? And the answer is yes, if it's reasonable, if it's negotiated and not unconscionable. And here's some examples. You know, you buy a house and the purchase and sale agreement, new construction, the purchase and sale agreement, if you got a problem, you have to assert a claim within a year. That's been upheld in the past. Case just got decided involving a franchisee. You know, the folks who make those swing sets that kids play on, and some adults. Well, a franchisee got into a beef with a franchisor. Creative Playthings Franchising Corp, I believe, was the franchisor. They sued a franchisee. The franchisee brought a counterclaim. Case was in federal court, and there's a procedure where if the federal court is applying mass law and they're uncertain about what the law is, they can ask a question of the Supreme Judicial Court as to what the law in Massachusetts is. It doesn't do much to speed up the process, but it's a way to get questions answered that may determine the outcome of the case. So here, the federal court asks the question, and a franchise agreement, which is governed by Massachusetts law, is a limitations period in the contract shortening the time within which claims must be brought valid and enforceable under Massachusetts law. And the answer by the Supreme Judicial Court just recently was yes, if the claim under the contract in the agreed upon limitations period is subject to the negotiation of the parties, is not otherwise prohibited by statute, is reasonable, is not what's called a statute of repose, we'll talk about in a second, and is not contrary to public policy. So the statute of limitations in the contract in the case basically said that you get 18 months to bring suit in the event of a dispute. But it's 18 months from when you knew or should have known of.
So the clock starts when your awareness starts.
And that's part I'm sorry. It's 1 year from when you knew or should have known, okay, or 18 months from when the act occurred. So when the act occurs, you may not know you have a claim. So when a claim is wiped out before you have any knowledge that you even had a claim, that's called a statute of repose. And the court is saying statute of repose is, you cannot agree to a statute of repose. The only way there can be a statute of repose is if it's passed by the legislature, a statute that is enforceable. And there are some. A common one comes up in construction contracts. There's after a certain period of time that the building is in use, all claims are gone. So if a building falls down 20 years after it's in use, those claims may be wiped out by the statute of repose. So you can't agree to a statute of repose. You can agree to a reasonable shortening of the statute of limitations, which is going to arise when you knew or should have known, and that makes it enforceable. So we have this concept of, the freedom of parties, particularly businesses, to contract with each other. So it's something that's worth thinking about as you put together terms and conditions for your agreements.
My name is Jeffrey Davis. This is Radio Entrepreneurs. We're talking to Mark Furman. Mark, this whole idea, excuse me, you look shocked, this whole idea of statute of limitations, I want to ask you one question before you go on. You mentioned the six years in Massachusetts. Can I get a sense of where that stands versus what's going on in the other states?
Pretty common. 6 years is pretty common. Tort for breach of contract claims. Tort claims are shorter, 3-year statute of limitations. Under Massachusetts law, consumer claims would be subject to a 4-year statute of limitations. And, but this, look, when you're dealing with consumers versus businesses, it's one thing, but when you have business-to-business agreements, then you're the notion of the freedom of the parties to have whatever contractual provisions that they want, that's a strong principle. Parties ought to be able to agree. Freedom of contract is how it's referred to. So, there's a little bit of a presumption of equal bargaining power. Not sure that that's always the case in a franchise situation. In a lot of situations, if you get offered an agreement with Google, that could be a gigantic contractual opportunity for you. In reality, Google is they're holding all the cards, and they're going to be able to impose their terms on you. So they're not going to be able to do anything completely unconscionable, but the reality is that there is unequal bargaining power in many agreements. But companies attempt to have their, they fight about, they try to impose terms and conditions with the provisions they want in them, and there's something called the battle of forms, where you have two companies contracting and they have completely inconsistent terms and conditions on their forms, and the question is which one applies. So statute of limitations is just one issue, but I think it's something to think about if you're entering into a substantial contract. Do you want a shorter or a longer statute of limitations?
Well, this is interesting. Since we assume that most entrepreneurs don't understand the law, I guess the onus goes both ways. One is on the part of the entrepreneur to say to the lawyer, what are my limitations and expectations on this contract, so that they're clear up front what their thing is. And it's also up to the lawyer, that's the legal counsel for the client, to keep the client informed too.
That's right.
And I'm starting to think that this has applicability to the new CRM products that are out there, that you could actually program into the CRM some products when the statutes and when these dates are up, so there's a pop-up, so you know that you're aware that that your time is running out on things, and you don't have to let something slip under the carpet.
Right. Well, if you right, the problem that comes up though is if you may not know the date that the statute of limitations begins to run. So, for example, if you buy a defective product and it was made improperly, but the problem doesn't reveal itself for 4 years,
right?
And then there's a problem, a big problem. You don't. There's a little bit of a premise in the law that that would be unfair for someone to lose their rights before they even know about the claim. And so, that's what the court's trying to do here, trying to have people be able to contract, trying to make sure it's reasonable, so that claims are not eliminated before people have the slightest knowledge about it. So, I think I think every entrepreneur, business owner should have some kind of terms and conditions of the agreements when they sell their products or provide, a service. There's all these things you can think about putting in or not, but I'd say give it some thought. Choice of law, choice of form, arbitration, statute of limitations, limitations on damages, limitations on warranties. There are things within limits you can do to protect yourself, and don't assume that every agreement is the same. It's all boilerplate. You don't have to be concerned about it. You don't have to be concerned about it unless there's a problem. But these provisions are going to have a major effect on you and your business in the unfortunate event that there is a problem.
Well, we've now reached the radio statute of limitations. This is, again, Radio Entrepreneurs, and we're talking to Mark Furman about statutes of limitations. Mark, if someone wants to get hold of you, how would they contact you?
I can be reached at 617-218-2025 or at mfurman, F-U-R-M-A-N, at tbhr-law.com.
And since there are no limitations to it seems to people's ability and willingness to litigate, you will be back again next week to talk to us about another story that's applicable to entrepreneurs.
Look forward to it, Jeffrey.
Great. We'll be right back after this break with more stories on Radio Entrepreneurs.